my insurance because I have military insurance.
That'd work.
Yeah.
That'd work. Mr. Sorensen, I've signed an order resetting the matter to January 2nd. Go ahead and get a copy of that at the window. Yeah, take care of yourself, be well, be healthy, and look forward to seeing you after the New Year's amateur night.
Yeah.
So, you take care of yourself.
You too. Thank you.
I will. Thank you. Morning, Mr. Haverco.
Morning, Judge. Morning, Judge. This is this gentleman here. I don't think I represent him. I think he's pro se before you this morning. He's I think the compliance matter.
Doing a quash and then rescheduling compliance so I can get it.
What's your last name?
Higgins?
This is Mr. Higgins.
Yes, good morning, sir. For the record, full name Timothy Allen Higgins.
He's answered.
Yes.
I am appointed. I have her go to represent you in this matter. You're here. You've been in warrant status multiple times. I can't count how
I do apologize. Like I said, I was getting removed from my home last time.
What I have is probably the thickest file that's active at this time. You were most recently discharged from treatment. Was filed November 20th.
Yeah, I gotta get you my new paperwork from Northwest. I've been trying to. I would rather be there in person with you today.
Mr. Higgins, the reason you're in jail is I release you and you don't, on your promise to show up for court, and you don't. And
like I said, I was removed from my home the last time we were supposed to have court. I do really apologize, Mr. Myers.
here, let me put it this way. Judgment and sentence was entered on March 3rd of 2022. And ordinarily 2 years of jurisdiction would have passed by now, except you've been in warrant status so many times. We still have
being homeless and back and forth from Northwest Resources to Yelm has been quite a feat for me. Along with the new kid and the newborn up in Rainier, it's really been trouble me getting back and forth. I do really apologize, Mr. Myers, and I do have the new paperwork from Northwest Resources for you for my compliance, and I'm really struggling to try, but I have been doing my best, keeping with the quashes with you guys and trying to keep in contact and keeping everybody up to date.
Okay, now let me finish. We're at the point where I keep hearing the same thing that you just said. You had 347 days suspended back when a judgment and sentence was entered on some conditions, and one of the conditions was compliance with any recommended treatment, but that just can't seem to happen.
I've been in compliance. I'm sorry they haven't gotten it over to you. I don't know why they haven't.
Please, let me talk. You're putting me in a position where I simply have to impose 347 days and let you sit it out and close the case. That's what you're doing.
Mr. Myers, I do have that paperwork. I'm sorry they haven't sent it to you.
Okay, it's one. The discharge statement, we just got it yesterday. That's it, because you've been out of treatment for quite some time. You were given a lot of chances to get back in treatment and haven't.
I've been in treatment, Mr. Myers. I don't know what they sent to you, but
You've been in treatment where?
With Northwest.
We just got a discharge from treatment yesterday that tells me that you have not been in treatment since.
Is that from the Lacey or the Spanaway? Yeah, I've been over on the other side. That's why it's been really hard for me to get back and forth between that and then the newborn up in Rainier. I've been really struggling. But I have been in compliance, sir. I have been going to Northwest. It's just on the other side.
I can understand the struggles, but you got to start by just showing up for court. You don't do that.
Absolutely, sir.
That's.
I would have really rather been there today in person. I planned on being there today in person. I had everything scheduled. I just
let me talk, okay? That's one last chance. Is that fair enough? One last chance.
I won't let you down, Mr. Meyer. I do really apologize.
Well, how many times have you had to apologize? We're going to reach
too many.
You better be have made some progress, or at least just show up in court. If I have
Absolutely.
to for your arrest, it's going to be to sit out 347 days at the Nisqually jail.
I can't do that. That would be really detrimental to me right now with a newborn, and as good as I've been doing in treatment. And I mean, I would really rather be there with you in person, sir.
Mr. Higgins, we're going to give it a shot. At least show up for court on January 2nd.
Absolutely.
It has to go back to warrant status. The warrant will get executed at some point. You'll be back in custody and then you're gonna be looking at some serious time before we finally close the matter, okay?
Absolutely, sir.
That's, Mr. Haverco, anything to add?
Oh, nothing to add, Your Honor. I'm sure he'll do his best.
We're gonna send down an order releasing you for a court date on January 2nd. Unless you have some other hold on you, you'll be released today sometime. But Mr. Higgins, now's the time to finally address the matter, okay?
Absolutely, sir.
I hope so. You take care of yourself.
Thank you.
Thanks, Judge.
Perhaps I shouldn't say one last chance because that's just puts me in a position to have to do the inevitable. I'll go ahead and pause the record. There you go. Morning, Judge. This is Paul Harvey Scott. Morning, Judge. This is Paul Harvey Scott. So Scott, you look a little different than the last time I saw you. Good morning. For the record, is your full name Paul Harvey Scott?
Yes.
I'll turn to your attorney for the status of the matter. You're set for pretrial hearings on 3 matters and arraignment on a 4th matter. Mr. Haverco.
That's great. That's great, Judge. I met with Mr. Scott, and I think the parties have a proposed disposition on this matter. We're proposing to waive arraignment. He understands his rights under arraignment to be read the charges in open court, enter a guilty plea, or we have to establish probable cause, we would choose to waive arraignment. And then in keeping with that, on the arraignment matter, plead guilty to count number 1, use deliver of drug paraphernalia, dismiss count 2, and as part of the agreement, dismiss item number 2, which is the case ending in 199, and then entering a plea to item number 3, which is the criminal trespass second degree case, and then also as part of the deal, city would move to dismiss item number 4 of the calendar, the case ending in 202. And I put a plea statement in the home courts.
Scott, do you disagree at all with anything that Mr. Havercode just said?
No.
I'm looking at the statement on defendant on plea of guilty to basically 2 counts. 1, use and delivery of drug paraphernalia, and loitering in connection with drug-related activity. Those are both misdemeanors. The maximum penalty on conviction would be 90 days or $1,000 per charge. You realize that?
Just to correct the record, Judge, he's pleading guilty to count 1 on item number 1, and then he's pleading guilty to the criminal trespass second degree and calendar number 3. Yeah, the criminal trespass, and then the other 3 charges to be dismissed.
Scott, the problem is you get so many criminal charges. I have trouble figuring out what is what. That is correct. To crim tres 2, as well as the other one. Both of those are misdemeanors. The maximum penalty 90 days on conviction and or a $1,000 fine. If I accept the plea, you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing, which could be up to the maximum regardless of what's recommended. Do you realize that?
Yes.
With that in mind, as to 1 count of use, delivery of drug paraphernalia alleged to have occurred within the city of Yelm on November 8, 2024, and 1 count of criminal trespass second degree alleged to have occurred within the city of Yelm on August 6, 2024. How do you plead guilty or not guilty?
Guilty.
You make those pleas of your own free will?
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No.
Find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 do satisfy the factual elements of each charge. Mr. Havercode, with the recommended sentence would be suspended jail time, no fine.
Right. Yeah. I mean, the city's very familiar with Mr. Scott. The city, because of his known indigency, homeless status. City's not asking for any financial obligations, just credit for time served, and the balance is suspended for the next 12 months on the condition there be no new criminal law violations.
Mr. Radfield, anything to add? Mr. Scott, anything you'd like to tell me?
No. They just told me to go under the bridge where I stay and to do drugs and not to do them in public, which I do.
Mr. Scott, it seems like the only time that I talk to you, or that you're arrested, I should say, is you're under the influence. It's apparent to the officer of drugs that you shouldn't be taking. We don't hear from you any other time, which indicates to me that you're not getting yourself into trouble when you're not using. Now, I'm starting to think maybe the only way of keeping you from stop using is to leave you in jail for about a year so you completely detox and get away from the drugs. Right now, how much jail time do we have suspended hanging over your head? I think it adds up to years. Is there some way you can stop using drugs and getting yourself into trouble?
Yeah, I can stop, and then, I mean, yeah, I can stop.
I certainly hope so. And to follow the recommendation, 90 days on each charge, all suspended, no fine. But Mr. Scott, you're very close to just winding up in jail and in a situation where you're going to be there for a year or so. It's up to you. Stop using the drugs.
Okay.
It's apparent to me that if you stop using the drugs, you're going to stop getting out of trouble.
Okay. Cool.
Now it's your choice. It's your choice. You take care of yourself. All right.
All right. Thank you. Thank you, Your Honor.
Trevor, go. Thank you. You take care. Certainly can. Mr. Van Vechten. Good morning. Good to see you. Here on behalf of Mr. DeFord. And Mr. DeFord, I don't see in the courtroom, but that's I was hoping that he would make it to treatment this time, but I'm inclined to, yeah, but I have no problem with city have any objection, Mr. Redfield?
No.
The only issue that might be is he's posted a bond and we've got to notify the bonding company. We don't have to do that, but if we want to forfeit, it's only a $1,500 bond. Let's. Okay. The December 19th. Any objection from the city?
Oh, no. City's doing it.
So ordered, yeah, that's on presentation. I'll sign an order. Refresh button. In fact, noting the non-appearance of Mr. DeFord for speedy trial purposes. Well, wait a minute, it's post-dispo. I guess I don't have to do that. Signed the order, closed. I guess all we can do is hope that he's in good shape, that yeah, and Mother can find a way to contact him. That's well, I was surprised too. If I had suspected that, it might not have been $1,500, but be that as it may, that's we just hope he's healthy. Sometimes that's not the case with these issues, but we'll hope he resurfaces alive, well, and healthy, and does make it into treatment. Sign the order. Get a copy of that if you want at the window outside the courtroom to your left, and for your file anyway. It'll have the court date and time on it. Should be there, yeah. I'm a computer dinosaur. I don't know. Thank you. The day. Mr. Van, thank you. You take care. Have a good one. Okay, sure. Daniel Barriga. Okay. And we have him for a couple of, well, sorry. Let's bring that up and we'll. Good morning, Mr. Ansing. We'll take your matters now. You're muted. If you'd unmute yourself. Good morning.
Good morning, Your Honor.
Ansing, we'll take your matters now. You're number one on the docket, representing Daniel Barriga. I see in O Courts a motion to reset that matter.
That's correct, Your Honor. Mr. Barriga is appearing through counsel, just asking to reset this to January 2nd.
City have any objection? And you're in touch with your client and.
I am, Your Honor.
So it's cruel.
Correct.
I'm signing the order as we speak, resetting the matter to January 2nd. That being the day after January 1, we're trying to keep that date a little light, but so be it. You also
We can reset to a later date in the month, Your Honor, if that's better for the court.
It's okay. Second is fine.
Okay.
Also on behalf of Justin Mora.
And good morning, Your Honor. Mr. Moore is present here on Zoom.
Mr. Mora, good morning. For the record, full name Justin Mora.
Yes, sir. Your Honor.
Mr. Ensing, I'll turn to you for the status of the matter. I'm looking at an SOC in Oak Courts. Turn to you.
That's correct. That's correct, Your Honor. So this time we have reached an agreement, proposed resolution for your consideration by way of SOC. So that would be a 6-month SOC to both counts, Your Honor. The infraction and then count 1, the criminal offense, Your Honor. I've reviewed this SOC document with Mr. Mora. I've reviewed it with him line by line, so he understands all the rights he's giving up in order to enter into this SOC agreement. He understands all the conditions he must meet to get the benefit of this agreement. He also understands the procedure if there were to be any allegations that he violated the agreement by way of reading the record and revocation.
Mr. Mora, do you disagree with anything at all your attorney just said?
No, Your Honor.
He's negotiated on your behalf an agreement under the terms of which these charges will go away. They'll be dismissed 6 months from now if you comply with your side of the agreement. And that's basically stay out of trouble. Is there a monetary agreement?
Yes, Your Honor. I agree.
I see a 0 in the cost assessment section.
Council should be 250.
I understand.
Sorry, I couldn't quite hear you, counsel.
Agreeing to pay a cost in the amount of $250.
Yes, Your Honor.
Hey, Mr. Mora, that's if you violate the agreement and the city proves that, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a criminal offense and a finding of committed on an infraction. Your attorneys put you in a position where you can get these matters dismissed without any penalty at all, other than compliance with the agreement. But whether you comply with that agreement or not, it's up to you and not your attorney. Okay?
Yes, Your Honor.
I'm signing off on the agreement.
Perfect. Thank you, Your Honor.
Sending your attorney and yourself a copy of that agreement. And I want you to look that over carefully. And if you have any question about what the agreement means, give your attorney a call, okay?
Yes, Your Honor.
Any question of me?
No, Your Honor.
I'm going to wish you the best of luck. You take care of yourself.
Thank you, Your Honor.
Thank you.
Mr. Ansing, I'm signing the order and closing it as we speak.
Thank you, Your Honor. Have a good day.
And you as well. Tuaninga, do you have the matter ready by any chance? Well, we could take that now. I note that and remember that from earlier. Good morning, sir. Mr. Miller, can you hear me okay?
I can hear you right now, yes.
Thank you.
And Your Honor, on guilty driving first degree. I have opportunity to go over this document with Mr. Miller. The elements of negligent driving, first degree, the important rights that Mr. Miller would be giving up by entering property attorney's recommendation. The fact that Your Honor is not bound by that recommendation, that Your Honor can sentence him up to the maximum of 90 days in jail and a $1,000 fine. The fact that Your Honor can set certain costs, fees, and assessments. I have gone over any immigration consequences. No. Thank you.
For the record, your full name is Michael Lester Miller, is it not?
Yes, Your Honor.
Do you disagree with anything that your attorney just said there on your behalf?
Yeah.
I'm looking at a statement of defendant on plea of guilty to 1 count of negligent driving, first degree.
Yes, Your Honor.
So misdemeanor, the maximum is 90 days in jail and or a $1,000 fine. I'd be free to impose that regardless of what's recommended. If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal.
And we talked about that, right?
Yes, 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 Your Honor.
With that in mind, as to 1 count of negligent driving in the first degree, on August 7th, 2024, amended down from a DUI allegation. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Do you make that plea of your own free will?
Yes, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense.
Yes, Your Honor.
Mr. Tuaninga, as to the sentence,
And Your Honor, this recommendations. For Mr. Miller, as you see, Mr. Miller has taken responsibility for this, not only the trial stage, he is here today in order to end this agreement. We ask that Your Honor follow this agreement, and I do not believe that Your Honor will be seeing Mr. Miller in a courtroom ever. Thank you.
Mr. Miller, I agree with your lawyer that we won't be seeing you again here.
No, Your Honor.
I'm going to follow the recommendation, 90 days suspended on the condition you have law-abiding behavior, and that especially applies to drinking and driving. $250 fine. Your attorney's done an excellent job negotiating a much less serious charge on your behalf. I hope you appreciate that, and I'm going to take your attorney's word that you have learned that you got to completely separate any drinking from any driving.
Thank you, Your Honor.
Good luck to you. Any questions?
No, Your Honor.
Anything further?
Thank you, Your Honor.
Sign the JNS and copies of that, of course, you can get at the window outside.
I have 2 more clients to take care of, but you can go ahead and get your paperwork at the front window, and I'll be out soon if you have any more questions.
You need me to wait for you?
No, you can go ahead and go if you want.
Thank you. Thank you.
Thank you.
Thank you, Mr. Miller. There we are.
And Your Honor, I hope you did not dismiss Mr. Miller.
Oh, that's just fine. Little whole courts issue here. I'll sign it, but they don't want to close it unless I sign it. I already have. Okay. Go ahead.
evaluation. And that was the, focus of communication in our last meeting, was him getting that deferred prosecution evaluation. So I saw the next date available was January 30th, and there's motion in no courts, selecting that date with a speedy trial waiver.
City, have any objection? Citing the order, restating the matter, Jason Turner to January 30th, 9 a.m.
Thank you.
Now let's see if we can close that.
So first, that same, January 30th.
Hearing no objection from the city, I'm citing an order resetting the matter to January 30th, 9 a.m.
Thank you, Your Honor.
Mr. Tuininga, thank you, and I'm gonna need a cough drop by the end of the day, I'm afraid. You take care.
My apologies. You take
Oh,
care as
no
well, Your Honor.
problem, no
Always
problem.
a pleasure.
That's just likewise. And I think that was. Good morning, Ms. Gammon. We'll take your matter now.
Good morning, Your Honor. Thank you. And I am appearing with Mr. Van Winkle, who is in the courtroom.
Mr. Van Winkle, come on up and have a seat if you would. Your attorney's present on Zoom. But good to see you. How are you? So far, so good. I'll try not to shout at you. And I am looking at an instrument in O courts. Ms. Ganem, I'll turn to you for the status of the matter.
Thank you, Your Honor. Parties have reached a resolution in this matter by way of a stipulated order of continuance. And I did have the opportunity to review this document with Mr. Van Winkle. We went through it line by line together, and he did read this independently on his own as well. We did review the rights that he is waiving by entering into this agreement, as well as the maximum penalty and any mandatory minimum penalty that would need to be imposed if this is ever a conviction. I've also reviewed each and every condition that he would need to comply with in order to get the benefit of the dismissal of both charges at the end of the time period. Your Honor, I also reviewed the consequence if he's unable to abide by the conditions, and that the court would rely on the documents currently in the record and most likely find him guilty if it comes to that. I do feel he is proceeding knowingly, intelligently, and voluntarily, Your Honor, and I would ask the court to accept the SOC.
Stratfield, anything to add? Any comment? Mr. Van Winkle, for the record, full name Justin Wayne Van Winkle.
Yes, Your Honor.
Do you disagree at all with anything your attorney just said?
Not at all.
That's the deal. She has worked out on your behalf an agreement under the terms of which 6 months from now, both these charges can go away, disappear, dismissed.
Okay.
If you keep up your end of the bargain, which is principally stay out of trouble. The other part of the agreement is a $250 cost, which you can pay at $50 a month. Now, your attorney's put you in a position where these charges will go away, but compliance with those conditions, or that's up to you. If the city proves that you violated a term of the agreement, we come back to court, we'll have a hearing based on the police reports, and as your attorney indicated, that may well result in convictions for 2 criminal offenses bearing significant jail time. We don't want to go there.
No.
You're in a position of getting these matters dismissed, but please comply with the agreement.
I will.
Any question at all?
No, Your Honor.
We'll be sending you and your attorney a copy of the agreement. What I want you to do is read it over carefully, make sure you fully understand it. And if you have any question about what anything means in the agreement, give your attorney a call, okay?
Okay.
I'm going to wish you the best of luck. You take care of yourself, and hopefully we all make mistakes. We learn from them or we repeat them, and hopefully this is something you've learned from and not going to happen again.
Not.
You take care of yourself.
Now, who do I talk to see if they have the correct address on file? Okay.
Yes,
You're
we
gonna
do.
mail it to me, correct? The agreement?
At-
Oh, you just got it
Or
right
if
there?
you want, it's, in the electronic age, the copy of it, you can have gotten at the window, before you even leave here today.
Oh, okay.
It was-
Thank you.
And make sure, confirm your address, with the out of court deputy.
I will. Thank you very much.
Mr. Van Winkle, thank you. You take care of yourself and have a good day.
Too.
Thanks for your patience. Again, that
Thank you.
You take care of yourself. Have a good day.
You too, Your Honor. Thank you.
Thank you. Morning, Mr. Everco. I'm going to defer to you for the order in which the cases are called.
Thank you, Your Honor. Call the matters, item number 1 and 2 on the 10 o'clock calendar, Lydia Dawson.
Good morning, ma'am.
And both matters come before the court for a couple of, one case theft and trespass, and another case of theft. Parties have reached an agreement. She's going to, on the case ending in 311, she's going to enter a plea to count number 2, amended to criminal trespass in the second degree, dismissing count 1. And then she's going to enter a plea as well to item number 2, ending in number 731. So she's going to enter a plea to 2 counts, one of which is amended to the lesser charge of criminal trespass. And,
Thank you.
yeah.
Good morning, ma'am. Full name Lydia Elise Dawson. I'm looking at a statement of defendant on plea of guilty to 2 different things. One is an amended charge, criminal trespass in the second degree. That's a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine, which I'd be free to impose regardless of what's recommended. You're also entering a plea of guilty to theft in the third degree, gross misdemeanor, the maximum penalty, 364 days in jail and or a $5,000 fine. Have you gone over the plea form with your attorney? Have you reviewed the matter with your attorney, gone over the form? And if you had any questions about what it meant to enter pleas of guilty to criminal matters, were your questions answered? Now, if I accept the pleas, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be, as I indicated, up to the maximum, regardless of what's recommended. With that in mind, as to 1 count of criminal trespass, second degree, alleged to have occurred within the city of Yelm on September 23rd, 24, and 1 count of theft in the third degree, alleged to have occurred within the city of Yelm on November 4th, 2024. As to those 2 charges, how do you plead, guilty or not guilty? You make those pleas of your own free will. Anybody make any threats or promises to you to make you plead guilty? I will find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. I'll listen to your attorney with regard to the recommended
It's an
sentence.
agreed recommendation, except that as the city customarily asks for, they ask for financial costs. I would ask the court not to impose any financial obligations. I am aware that she and Mr. Wolf, who's on the calendar today, they're essentially homeless, and I have no doubt that they are. So they're both indigent. So ask the court to follow the city's recommendation, except for not to impose any costs.
Mr. Ratfield, anything to add to the recommendation? Ms. Dawson, you have a right to tell me anything you wish. You don't have to say anything, but if there's anything you want me to know about yourself or the situation, now's the time. Dawson, we all make mistakes. You better learn from these mistakes here and not repeat them, okay? Think before you act. It's always a good policy. I'm going to follow the recommendation. 90 days on the criminal trespass charge, 364 on the FF third charge, all suspended on one simple condition: stay out of trouble. Given your financial situation, I'm not going to impose any fine, but you do have the suspended jail time hanging over your head, so think before you act. Any question at all? I'm signing the judgment and sentence as we speak. What I want you to do before you leave is go to the counter out of the courtroom to your left, get a copy of today's paperwork, and look it over carefully, and if you have any question about what it means, get a hold of Mr. Haverhill, all right? I'm gonna wish you the best of luck in the meantime, and whether I see you again is up to one person, and I'm looking at her right now. Stay out of trouble. Thank you, ma'am.
Mr. Wolf?
Oh, boy.
Go and sign here.
Is this Mr. Wolf?
He's tying a shoe or something. This is Mr. Wolf. Give me a second here. So this is Mr. Wolf here, and he has a couple of pretrial matters, and the parties have reached an agreement. And that is on item number 13, which ends, or it doesn't matter the item number, but the case ending in 312, criminal trespass first degree. He's going to enter a plea to that charge, but to the reduced charge of criminal trespass in the second degree as part of the agreement. The city would then move to dismiss the controlled substance violation case ending in number 727.
Good morning, sir. Is your full name Joshua Harold Wolf? Do you disagree with anything that Mr. Haverhill just told me? I am looking at a statement of defendant on plea of guilty to one count of criminal trespass, second degree, amended down from first degree. Also that the plea form also references a dismissal of a knowing possession of controlled substance charge. You realize that? Criminal trespass, second degree, is a simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine, which I'd be free to impose regardless of what's recommended. You realize that? And if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no witnesses, no appeal, simply that sentencing. Have you gone over the plea form with Mr. Haverhill? And if you had any question about what it meant to plead guilty to a criminal offense, was your question answered? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. Mr. Haverhill, the recommended sentence?
It's the same thing, Your Honor. He's, partners with Ms. Dawson,
Yes.
and they're both essentially out kind of on the streets together, homeless quite a bit of the time. So he's indigent and asks the court to follow the city's recommendation except for the fine, and asks the court not to impose any costs.
Sure. Bradfield, anything to add? Mr. Wolf, anything you'd like to tell me? Now's the time. If you have anything you want me to know, you don't have to say anything and can rely on what your attorney said if you wish. Your choice. Anything you'd like me to know? Take it easy. Mr. Wolf, the charges being dismissed is actually the more serious, of course, of the charges. And what I'm going to ask you to do, I'm not going to order you to do anything, but save your life, save your own life, get off the drugs. That was, too many people are dying as a result of what's available on the market and on the street today. To follow the recommendation, 90 days in jail, also suspended on the condition of law-abiding behavior. And I don't think I'm going to impose any fine based on your financial situation. I want you to stay out of trouble. I want you to focus on that, not making any fine payments, all right? Whether you're back here again, sitting in that chair again, is up to one person, and that's you. Learn from the situation and whatever it takes to get off any controlled substance. I advise you address that. Good luck to you. Again, excuse me, I want you to get a copy of today's paperwork at the window. Read it over carefully, and if you have any question, give Mr. Haverco a call, okay?
Free to go. So this is Kelly Kincaid. Matter comes before the court for a pretrial hearing on a minor in possession charge. Parties have reached an agreement, that being a 12-month stipulated order of continuance, $250 court fee, and no new criminal law violations, and she's under 21, so the admonition that she not drink alcohol.
And for the record, is your full name Kelly Lee Kincaid? I'm looking at a SOC, stipulated order of continuance. What this is, basically, it's a contract, an agreement between yourself and the city, negotiated by your attorney. They're on your behalf. Under the terms of this agreement, period of time goes by, the charge can be dismissed. Now, if you violate any term of the agreement, we'll come back here. We'll have a hearing based on the police report. You haven't given up your rights, and that'll most certainly result in a conviction for a criminal offense. Conditions, of course, are $250 probation fee and simply stay out of trouble. That's the most important one. Now, yeah, you're under 21. It's against the law for you to drink. And one of the major reasons for that law is and I've seen this happen time and time again. If you've been drinking, you're susceptible to bad things happening to you. You're vulnerable to the predators that are out there in the world. Take care of yourself. Be protective of yourself, and don't. Make sure it'll be not legal for you to drink until you're 21. But I want you to take care of yourself. Any drinking, make sure you're in a safe environment. Best advisement is wait till you're 21. Any question at all? Ms. Kincaid, what I want you to do is go to the window outside the courtroom to your left, get a copy of today's agreement, look it over carefully, and if you have any question, give Mr. Haverco a call and clarify them. Any question? Good luck to you. You take care of yourself. That's, maybe you picked up from the news, the 20-year-old, the sisters in Seattle, 20 years old and 17. 20 years old was driving. She was impaired. She'd been drinking. Drove the car off a pier into the water. Her 17-year-old sister drowned. So she's now in jail for killing her sister, basically. That's where this goes. So take care of yourself. Again, get a copy of of today's order and be good to yourself. Take care of yourself and have a good life outside of any sort of custody. That's all I can do. Take care.
Good luck. Emmanuel Mendoza. Trial waiver motion for continuance.
Good morning, sir. Full name Emmanuel, middle initial L, Mendoza. Good morning.
We've just placed a motion for a continuance in O courts with a speedy trial waiver. He's just been, he knows he needs to get an evaluation. He's just been sort of busy working. And so he and I had a discussion in the last few days, and I explained to him that you really need to get that done. And so he's gonna gonna work on getting that done.
How far out would you like to go?
How long do you think we need? If the court would be willing to set it into January, where
January
new
30th?
commencement date is beginning of January.
Let's go to January 30th. I realize this is between Thanksgiving, Christmas,
Right.
kind of a busy time of
Right.
year. Mr. Mendoza, I can appreciate having to work, but, you're not gonna be able to work if you're in custody because there's a problem with it. So it's better to, address this matter very seriously. Stay in touch with your attorney. Any conditions of release earlier set remain in effect. We're resetting the matter to January 30th at 10 o'clock, 11 o'clock, 11 o'clock. Signing the order of resetting now. Mr. Mendoza, what I want you to do is go to the window outside the courtroom to your left, get a copy of today's order. It has the time and the date on it, and make a note of it, and we'll see you back here next year. Any questions? Take care of yourself, sir.
Next matter, when the court's ready, will be John Smith.
Smith, come on up and have a seat. Now I'm back. Mrs. Smith, good morning.
Kind of
Sure,
comes
go.
on for it's a compliance issue. He entered into an SOC, towards the early part of the year. And, I think he just recently submitted proof of the evaluation, I believe. But he hasn't done what else he's supposed to do, like the costs and, victim impact panel and all of that. And, we had a discussion about it. I think he may have been, misunderstanding that, if he allowed the case just to be revoked, he wouldn't have to do those things. And I explained to him that, well, if the case were revoked and a DUI were entered, the court would highly likely reimpose those same conditions, because in a DUI case, court is likely going to order an evaluation, all of those alcohol related requirements. So it's really to his advantage, to try to comply, because if he were to comply, he gets the benefit of a negligent driving first degree. So, I think he indicates to me he's ready to really work at this, and, he's gotten off to a slow start, but we're asking the matter be reset for another review hearing to, see, if he can make some substantial progress.
So do you have any position? It's between the city and Mr. Smith. Mr. Smith, what Mr. Amico just said is very, I've seen this happen in many courts over many, many years, too many years, in fact. Somebody violates their probation or doesn't follow through and say, I'll just take the conviction. So they get convicted and the same conditions are imposed anyway. So that's not a good way out of it. And besides, a DUI conviction is horrific on your record. It's a license suspension, increased insurance premiums. It's kind of a disaster. Let's reset the matter out to September or January 30th, maybe. Let's set it out to January 30th. Give you time, but my best advice is that we jump on this with both feet and bring yourself into full compliance. And the city's benevolence here that to give you the chance to do that. It's not my agreement, it's yours and the city's. I find you violated it. We're back to square one. I can put you, if I find you guilty, that's jail up to 364 days with all the other conditions that go along with that. That's the best I can do, is advise you to, if you want the advantage of the SOC, jump on the obligations. Order is being prepared at this time. at 8:15, January 30th at 8:15 in the morning for a review, signing the order, resetting. And it's a good thing Mr. Haverko has prevailed upon the city to give you a chance to follow through on the agreement. Whether you do or not is up to you. So Mr. Smith, good luck to you. Take care. Any questions at all? Get a copy of the today's order at the window outside the courtroom to your left. And stay in touch with Mr. Haverko, and we'll see you back here end of January. See you next year. Take care.
Next matter is gonna be Bert Turner.
Bert Lee Turner. Good morning, sir.
I don't know if the city will have a motion. It might have a motion. He's currently suspended in the 3rd degree. The charge is 2nd degree, but I checked his driver status and he's 3rd degree, so.
Your Honor, city means it's normal motion to admit to no fault.
And I've discussed with him, he will admit to that.
Attorney, do you agree that you didn't have a valid license when you were driving on January 14th? It's a simple infraction. I'll impose a $150 fine. That takes care of the matter. You're suspended 3rd now. It's do you know what you need to do to reinstate? You know, to get your license back? Probably it's money, usually. I jump on that. The sooner you get reinstated is the sooner you can start driving. And we live in a world where you pretty much got to be able to drive. So. Signing the infraction disposition as we speak. It's $150 fine. You can pay that $25 a month. First payment due December 21. And of course, yeah, this disposition, it'll have no effect on your license as far as whether you can or cannot. If you would get a copy of the order at the window, and you take care of yourself. Thank you, sir.
let's move to the 1 o'clock calendar briefly. And if we could take up the matters of Victor Manuel Macias Perez.
Good morning, sir. Have a seat. Full name, Victor Manuel Macias Perez. We'll address your matter now.
A couple matters. He's got a sentence compliance case on a DUI from earlier this year, and then he has an arraignment. So what we'd like to do is proceed with the arraignment on the new charge, and or not guilty plea, and then reset it along with the sentence compliance case.
Morning, sir. We converted your name. Citation I'm looking at alleges that on or about November 8th, 2024, you drove a motor vehicle within the city of Yelm while your license was suspended in the 2nd degree, and you were likewise operating a vehicle without ignition interlock when required to do so. Have that by the Department of Licensing. Those are both gross misdemeanors. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in these matters, and he'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, and ask the court to enter not guilty, please.
Plea of not guilty has been entered. That preserved your rights. Any action at this time with regard to the compliance? Simply calendar that along with the new charges. Plea of not guilty has been entered. Mr. Macias, let's stay in touch with Mr. Haverco. And again, conditions of release in this matter, the new matter, are don't drive unless licensed and insured, and law-abiding behavior, which would include having an ignition interlock if you're driving as well. Any question at all? This might be something you have to talk to Mr. Haverco about.
I do leave alone, and there's no way not right.
There's no way you cannot drive. The defendant's saying he's advising there's no way he cannot drive.
Well,
Yeah, like, initially you said, everybody makes mistakes. I made a mistake, indeed.
Mr. Macias, the Department of Licensing is the one that suspends licenses. I don't have anything to say about whether they do that or not in this situation. If you drive, that's subject to arrest for a gross misdemeanor. If you're 2nd degree suspended, that's all I can tell you. Resetting your matters for December 19th at 10 in the morning. You need to be here at that time, and we'll address both matters then. What I want you to do is make sure Mr. Haverco has your current contact information, and I want you to get a copy of today's order at the window outside the courtroom, and to your left, if you would. That concludes the hearing. You're free to leave, unless you have something to talk to Mr. Haverco about.
Yeah, you're free to go. Yeah. But just give me a moment.
You can have 2 moments if you wish.
Okay. Hang on real quick second. Court's ready. The matter comes
Yes.
before the court. This is from Maritson on the 11 o'clock calendar. Let's see. Matter comes before the court for DUI.
Good morning, sir. Full name Travis Bryan, Moritz.
Yeah, I spoke
Mr.
with
Moritz, I'll turn to your attorney.
I spoke with the city. They were willing to agree to a 2-year stipulated order of continuance. What we call in the business a slow reckless. The charge to be amended to reckless driving at the end of 2 years if he complies with the conditions. All the DUI related conditions. Alcohol drug evaluation, victim impact panel within 90 days. I made a note that alcohol drug information school is waived if treatment is recommended, which I would anticipate probably would be. You know, and then the $990.50, which would otherwise be the fine on a DUI. Those are the costs. And yeah, just ask the court to inquire.
Sir, I've heard from Mr. Haverco. Do you disagree at all with anything you heard from him? Anything he just said? Do you disagree with anything he said? What you have here, he called it a stipulated order of continuance. It's called a lot of different things. What it is, essentially, is a contract, an agreement between yourself and the city, negotiated by your attorney, under the terms of which the most serious misdemeanor charge, I think, DUI, in 24 months can be amended to a much less serious charge of reckless driving. You need to comply with the conditions set forth in the agreement. The most important one to me is no law violations, no similar law violations, especially $990.50 costs, and also get a drug and alcohol evaluation and comply with any recommended treatment. Very likely it's going to be a drug and alcohol information school and a victim impact panel is what's most likely going to happen. And the purpose of the evaluation is, hey, if there's a problem here, let's deal with it, let's fix it, and go on with life. That's we'll expect to get a copy of any evaluation within the next 90 days. To do that, hopefully in 24 months, we can amend the charge to reckless driving, and it will go on your record as such. The city is willing to agree that alcohol and drug information school is waived if unless treatment is recommended. If it's not a requirement of the agreement, but I would advise you to take the class and maybe even do the victim impact panel just for educational purposes. It'll be up to you. It's not part of the agreement. Signing off on the agreement, what I'll want you to do is get a copy of it, read it over carefully, call Mr. Haverco if you have any questions, and remember, keep in mind, you've given up your right to go to trial. have witnesses, appeal if you lose. If you violate the agreement, we'll have a hearing based on the police reports. Don't forget this. And that would almost certainly result in a conviction for DUI, subject you up to 1 day less than a year in jail, with license suspensions, increase in, with all that goes with it. So good luck with you. I'm really hoping you've learned from this, and mistakes happen. We have them. But they learn from it, and don't repeat it. So Maritza, good luck to you. You take care of yourself.
Good luck. So on the, was that on the 10?
Page 10, docket number 10.
Oh,
I think, if I recognize.
okay. Gotcha.
Good morning, sir. Are you Rudolfo Romero? Okay. We'll take your matter now.
So this is Mr. Romero. He comes before the court for pretrial hearing. He's going to enter a plea to the charge. There's a statement of defendant on plea of guilty in all courts and ready to proceed.
Good morning, sir. Once again, is your full name Rudolfo Romero? Mr. Romero, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. Plea form tells me you're 38 years of age. Is that correct? Have you gone over the plea form with Mr. Haverco? And if you had any question at all about what it meant to plead guilty to a criminal offense, was your question answered? Any questions you'd like to ask me? If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no witnesses, no appeal if you lose, simply a sentencing, which could be up to 364 days in jail and up to a $5,000 fine, regardless of what the city's recommended. You realize that? That in mind is to 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on September 6, 2019. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty? I'll find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 of the plea form does satisfy the factual elements of the theft in the 3rd degree. Recommended sentence, Mr. Haverco, is?
Just a standard recommendation, all suspended jail time. The court fee is typically recommended by the city, and for 12 months, just commit no new criminal law violations.
City have anything to add?
No.
Mr. Romero, you can tell me anything you want me to know. You don't have to say anything. But if you want me to know something about yourself or the case, now's the time. I'll take the head shake as no. I'm going to follow the recommendation, 90 days, 364 days, excuse me, all suspended on the condition you pay a $250 probation monitoring fee and stay out of trouble. Most importantly, stay out of trouble. The fine is the least important thing to me. If you have trouble making the payments, you can pay that at $25 a month. Let us know. We can deal with that. But don't let it go to a warrant status. I want you to get a copy of today's paperwork at the window outside the courtroom and to your left. Look it over carefully, and if you have any questions, you've got contact information for Mr. Hammond. Hey, take care of yourself. Good luck. Yeah, 90, they're 364, 364. Yeah.
Nobody's here. Okay. A lot of folks not here from the 11 o'clock.
Well, and it's not so very early. Well,
Yeah.
we'll give it a few.
Yeah. I don't know if on concerning item number 8 on the 11 o'clock, the Tanner Lunsford. And then I believe he has the case also on the 1 o'clock. Okay, well, okay, and we can wait till 1. I just let the court know I got a phone call from his mother. He apparently went into some kind of inpatient treatment program. I called the number that she left me, and it's a real treatment place in the Vancouver, Washington area. He had just gone into treatment right a little bit before court, and I did ask her if she could email me or the court or give me a little more information as to how long he would be in. And I have not heard back from her, but she sounded like his mother, and I mean, I don't have any reason to think that it was a phony call, so.
The 1 o'clock is TWS 3rd.
Yeah, so maybe I'm calling a little too early because he hasn't technically failed to appear for his 1 o'clock, so. So, I don't know, assuming this is all accurate, and assuming he doesn't show for the 1 o'clock, I guess my request is just gonna be to note the non-appearance for speedy trial purposes, and arraignment purposes.
That's what we should do.
Just to reset.
Hear it, any problem with doing that? Just reset. Okay, that's what we'll do. We'll wait till 1 o'clock. And for now, yeah, if we'll note the non-appearance. Well, he has not appeared. It's 11:15 for the 11 o'clock hearing.
I did.
Won't issue a warrant, but just reset. Reset with notice.
And on the 10 o'clock calendar, I know we're not technically doing warrants yet, but I received a note from the clerk concerning Marcus Williams. He's item number 13 on the 10 o'clock calendar. Says can't appear to being sick. I will say that I do have a phone number for him, and it's the same thing as the number he left with the clerk. And I did call him and left a message, and he did call back where I missed his call. So we were kind of doing a little bit of a phone tag. So I have had some contact. So I would ask the court to note the non-appearance and reset with notice.
Note the non-appearance for speedy trial purposes, reset with notice to Mr. Williams. He's been in touch. That's good enough for me.
And did we want
Mr. Pettit, how about Mr. Pettit?
let me give you my notes here. I mean, let me see. So my notes for Mr. Pettit are, I did have a phone number. It wouldn't take a voicemail message because his voicemail probably is not set up. Anyway, so I did text him within the week saying, hey, this is your lawyer with Yelm, please contact me. I haven't received any return Communication.
1,500.
So ordered. He's got three matters, 500 each. I think that's it for the 10 o'clock.
Yeah.
Ah. Sorry, I'm sorry, Brian Flint, doc number 3, page 6.
Oh, Flint, Mr. Flint, when he was in court, he didn't know, when he was in court at his arraignment, he, didn't know or wasn't sure if he was going to have a phone number, but he had my contact information. I told him, well, as soon as you can, advise me of your phone number. So I have some way of contacting you, and I haven't been contacted by Mr. Flint.
Well, anybody can find a phone to call.
Yeah.
So ordered.
Are we doing the 11 o'clocks yet, or did you want to wait, or?
Well, we can wait. Back on the record.
Okay.
Back
So-
on record for the no shows from the 11 o'clock calendar, it being now 11:34. The first one I have is Mr. Ehrlich, docket numbers 1, 2, and 3.
And, I don't think I've had Mr. Ehrlich, I don't think I've had contact, but I had just prepared a motion for continuance if he were here to then continue the pretrial matter along with the arraignment matter.
If you haven't heard from him and he has to appear for 11 o'clock, I very much doubt that he's gonna be here at
Right,
1 o'clock. I would be shocked,
Right.
surprised, astonished if he was here at 1 o'clock.
I would as well.
1,000 cash or bond so ordered. Then the mitigation pedestrian, FTA.
And on Zachary Konoski, I don't have a phone number. So I was anticipating if he showed talking with him at court, so I just don't have any information.
That was controlled substance,
Yeah, no contact.
No, I
None.
don't have a number.
Okay.
so ordered.
And on Mr. Dennis LeBlue, I had a number and I called and left a message, to call me back and haven't received a return call, so I don't have any information to provide.
Grim Trust 2, times 2, and DDoS third. So ordered.
And Mr.
Robert,
Colton Williams, when he was here for his arraignment, he advised he did not have a phone. So I don't have any contact information.
and he hasn't contacted you?
No.
No. Again, a controlled substance case. It's,
Yeah, 15.
so ordered. And Ms. Yandas will wait on with, and hope that she
Yeah, never know.
Now on record for the 1 o'clock matters, I'm going to call a private council matter first. Maria Rogers Aiden in the courtroom. Ma'am, come on up, have a seat at the council table. Full name, Maria Gabrielle Rogers Aiden.
Yeah, Mariah Gabrielle Patricia Rogers Iden, AYDIN.
Okay, thank you, ma'am.
Thank you.
Citation alleges that on or about November 15th, 2024, you committed the offense of reckless driving. It's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to turn at this time to your attorney for the entry of a plea on your behalf.
Good afternoon, Your Honor. Acknowledge receipt.
Certainly.
This Rogers Aiden is charged. In the police report, the responding officer basically
Bradfield, any response at all? I have reviewed the officer's report as well, and I agree with you that it's pretty skinny as far as probable cause goes. But as far as a PC finding at the probable cause finding at the outset of a case, the threshold is extremely low, and although the officer's report does leave, I think, a lot to be desired, I'm going to find that there is sufficient probable cause for purposes of this hearing only, with my reservations. A plea of not guilty has been entered. That preserves your rights, ma'am. We'll set the matter for a pretrial. We have court 9 a.m. on opposite Thursdays. I'll defer to Madam Clerk for the next available. Does December 19th work? So set the hearing for them. Conditions release, of course, are law-abiding behavior. Stay in touch with your attorney and appear for court as directed. Usually with private attorneys, we allow appearance by Zoom by the attorney if your counsel so wishes, but I like to have the defendant in court in person. I'm signing an order resetting the matter for a pretrial on December 19th. The plea of not guilty simply preserves all your rights pending any further proceedings. Any questions at all? I'm signing today's order. You can get a copy of that at the window outside the courtroom to your left, and it'll have the necessary information on it. Any further questions? Concludes the hearing. Thank you. I'll say to everybody present that I take private counsel matters first. Attorneys are always on the clock, and I don't want to run up anybody's costs unnecessarily. We do have a public defender who will be in court and represent each and every one of you for purposes of this hearing at least. You're here for an arraignment, which is your first appearance after receiving a criminal citation. Before I call you up on at the time, there's a couple of things you need to know. One is you have a right to have a lawyer represent you at all stages of any criminal proceeding, and I'll appoint a lawyer to represent you at public expense should you be indigent and require the services of an attorney. Typically, almost always, a plea of not guilty is entered at the arraignment. Set the matter for a pretrial, which is a chance to discuss your case with your attorney, and he in turn or she in turn with the prosecutor. If you can reach a resolution of the case by agreement, that's put on the record. If you can't, you do have a right to a public and speedy jury trial in the county where the offense was alleged to have been committed. That in mind, any other private counsel matters? Okay. And Last name was? Good afternoon, sir. Is your full name Henry Edward McDinch?
Henry Edward
McDinch, a citation I have alleges that on or about November 9th, 2024, you committed the offense of driving under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. At this time, I will turn to your attorney for the entry of a plea on your behalf.
Your Honor.
Stipulation to PZ for purposes of this hearing only. Okay.
For purposes of this hearing.
Okay, thank you. Mr. McDinch, believe not guilty preserves your rights. We're going to set the matter for a pretrial. I did hear December 19th. Does that work? December 19th at 9 a.m. Does that work? That's conditions of release, of course, law-abiding behavior. Stay in touch with your attorney. And given the nature of the charge, don't drive unless licensed and insured. Any officer asks you to take a breathalyzer, you're to do so. And no drinking and driving at all. Signing an order resetting the matter to December 19th. Concludes the hearing. And again, if private counsel wishes, you can appear by Zoom, but I do want your client to be in court.
Understood.
Yes, you can get a copy for both of you at the window outside the courtroom to your left. We'll talk to you again on the 19th. So McDinch, take care. Well, we're going to take your case next. Juan Martinez Parada. Mr. Mo, good afternoon. Do you solemnly swear or affirm that you will accurately translate from Spanish to English and English to Spanish all that transpires here? For the record, I just sworn in Mr. Leroy Mold, who's a certified court interpreter. Good afternoon, sir. Is your full name Juan Manuel Martinez Parada? Citation alleges that on or about November 17th, 2024, you committed the offense of driving under the influence of intoxicants. November 17th. The charge is a gross misdemeanor with a maximum penalty 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. And he will enter a plea at this time on your behalf.
Stipulate to probable cause, Your Honor. Ask the court to enter a not guilty plea.
Mr. Martinez, that plea preserves your rights. We're going to set the matter for a pretrial on December 5th at 10 a.m. I'm going to sign an order setting that as your next court date. When you leave here, I want you to go to the window, get a copy of today's order. Conditions of release are law-abiding behavior, don't drive unless licensed and insured, and no drinking and driving at all. electronically signing the order. I want you to get a copy of that at the window. Donnie, for some reason, it's like, well. Currently getting, oh, wait a minute. Martinez, any questions at all? We'll see you back here on December 5th. Thank you. Going back to the top of the calendar. Maybe one more. Is Mr. Alejandro Almaral Nieves in the courtroom? Is here. Good afternoon, sir. You would have a seat. Is your full name Alejandro Almaral Nieves? If I mispronounce your name or anybody's name, I apologize. Citation alleges that on or about November 9th, 2024, you violated the terms and conditions of a protection order. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor. Ask the court to enter not guilty plea.
Plea of not guilty preserves your rights. What I want you to do, go ahead. You have a question? I didn't quite. Could you repeat that?
This is providing.
Yes. I think this is something you need to talk to Mr. Haverco about.
They don't take the. Your phone number?
Anything I can?
No, I think earlier he was basically telling the court he wanted to plead guilty to the charge. I told him that that's not something we do at this stage of a case.
Mr. Amaral, I never accept a plea of guilty at an arraignment. If you plead guilty, there's a number of things that can happen when you haven't talked to a lawyer, so you don't know whether there's a valid case against you or not, or if there's any defenses. And two, there's a lot of things that can happen. You can get jail from no time at all to almost a year in jail. So until you discuss the matter with an attorney and see what the alternatives are and the possible outcome of any plea would be, I don't want to accept a guilty plea. Thank you.
So you're gonna get copies of paperwork.
Again, I'll repeat this again, but if you have any questions at all about what happened here today, you're going to get a copy of the today's order by going to the window outside the courtroom. Look that over. It has Mr. Haverco's contact information on it. If there's any question, give him a call. And somebody raised their hand in the back of the courtroom. Wanted. Address that. I wanted Mr. Haverco to hear what you have to say, if anything. That's all right. That's all right. We'll get to you. That's eventually no problem. How about Nicole Barker? Does not answer. You don't appear for court. Good afternoon, ma'am. Are you Nicole Diane Barker?
Are you Nicole?
Go ahead and have a seat. Ms. Barker, the citation I have alleges that on or about November 10, 2024, you committed the offense of disorderly conduct. That's a simple misdemeanor. Maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. That's just the maximum that could happen upon, that's not something that's going to happen. I'm going to appoint Mr. Haverco to represent you in this matter, and he's going to enter a plea on your behalf at this time.
Stipulate probable cause and or not guilty plea.
Ms. Barker, what I want you to do is give your attorney contact information. And the order, you're going to get a copy of today's order at the window outside the courtroom to your left, and it'll have his contact information on it.
Oh, thank you. Thank you.
He'll need your information right now.
What is it? 319. Okay. All right, that's good. Okay.
Barker, thank you for appearing. Don't forget to get a copy of today's order, and Sanchez be back here on December 19th, 11 o'clock. This will be in the order for a pre-trial, but most of all, stay in touch with your attorney. Any questions? Yes, that'll be in the order.
Okay, you're done. You can leave, get a copy of the paperwork before you go. Yeah, go to the window. Yeah. Yeah.
Thank you, ma'am. Allison Bartlett. Good afternoon, ma'am. Is your full name Allison, middle initial R, Bartlett? Citation alleges that on or about November 11th, 2024, he committed the offense of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Bartlett, I'm going to appoint Mr. Haverco to enter a plea on your behalf, and he'll do that at this time.
Stipulate probable cause, Your Honor, ask the court to enter not guilty plea.
Ms. Bartlett, plea of not guilty, preserve your rights.
Okay. Three, 358. Is that a 3?
Yeah.
Pardon? Just relax. That's no plea of not guilty. That preserves your rights until you've had a chance to talk to Mr. Haverco about the case and decide whether you're going to resolve it by agreement or not. But relax.
Yep. 3, 358, 658. 385, not 3. Okay. Okay. All right.
And that concludes the hearing.
Yep.
Get a copy of the order at the window, and we'll see you back here December 19th. Take care of yourself. Christopher Benishak does not answer. Kevin Bingaman will come back to. Jacqueline Michelle Shannon will come back to that matter as well. How about Charles Elkin? Good afternoon, sir. Go ahead and have a seat. Full name Charles, middle initial W, Elkin. Mr. Elkin, you were cited for no valid operator's license without identification. The city may have an amendment to your case here. The city is moving to amend the charge from no valid operator's license without identification to with identification. Here's the difference. Without identification is a criminal offense Upon conviction, you could get up to 90 days in jail and up to a $1,000 fine. The new charge is what they call a civil infraction, like a speeding ticket or a jaywalking ticket. There's no jail time, it just bears a fine. If you admit, you don't plead guilty or not guilty to a civil infraction, you admit it or deny it. If you admit you didn't have a valid license on your person when you were cited on November 4th, what I'll do is I'll fine you $150 and that takes care of the matter. Any question about anything I just said? Do you admit or deny? Are you able to get a valid license? At least get an ID card. So. Oh, no. Unfortunately, it's almost seems like I think you're gonna have to go to Arizona and talk to the Department of Licensing there. Do you have any contact in Arizona, an attorney or family friend, anything? What I would do is talk to them and see if they can help you out with this. Because unfortunately, dealing with an out-of-state license impediment, sometimes that's pretty difficult. I'm going to wish you the best of luck with that. I want you to get a copy of today's order at the window outside the courtroom and to your left. And if you have any issues making the fine payments, let us know. We can deal with that, okay?
Thank you.
Mr. Elkin, good luck in getting your license reinstated, but at least get an ID card so you can identify yourself.
Thank you.
That'll save you some trouble. Thank you, sir. How about James Dean Haas? Did Mr. Haas show up? Not this time either. Kenneth Jaden. Good afternoon, sir. Is your full name Kenneth Russell Jaden III? Mr. Jaden, the citation I have alleges that on or about October 23rd, you committed the offenses of DLS third degree. That's a misdemeanor, maximum penalty on conviction, 90 days and or a $1,000 fine. You're also cited for operating a motor vehicle without ignition interlock when you were required to have that. That charge is what they call a gross misdemeanor. The maximum penalty upon conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter and enter a plea on your behalf.
Stipulate probable cause, enter not guilty plea.
Mr. Jaden, a plea of not guilty has been entered on your behalf.
Right.
Go ahead, sir. Somebody told you if you need a letter from the court? A letter from the court to the DMV? Mr. Haverco, are you aware of any? I'm not aware of any such. Mr. Jaden, the Department of Licensing is the one that suspends licenses. I don't have anything to do with that. I've never heard of, as long as I've been doing that, any sort of a letter that I could send to Department of Licensing. They don't do what I tell them to do. And with the Department of Licensing, it's been my experience, and I've said a few times, if you call them 10 times, ask 10 people the same question, you're going to get 10 answers, all different times. So, no, if your license is suspended third degree, that means eligible for reinstatement. And ask somebody at Department of Licensing, maybe go in, what do you need to do to reinstate? Usually it's an unpaid ticket, could be any one of a number of things, but that's the most usual thing. I've signed the order on today's hearing. Mr. Jaden, December 19th, the 11 o'clock is the pretrial. And I'm sure that if you're under ignition interlock requirement, what you'll need to, maybe what they were talking about was this, is you need to file proof of ignition interlock. I have no idea. This might be something to consult with Mr. Haverco today, but something we can't really go into right now. That's Mr. Jaden, I'm going to wish you the best of luck. You take care. Don't forget to get a copy of today's order at the window. Thank you, sir. Matthew Johnson in the courtroom. Good afternoon, sir. Have a seat. Full name, Matthew Paul Johnson. Right. Mr. Johnson, citation I have alleges that on or about November 10th, 2024, you committed the offense of being in physical control of a motor vehicle while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty and conviction to be 364 days in jail and or a $5,000 fine. You're also cited for obstructing a public servant, disorderly conduct, and having a weapon which is prohibited in a certain place. Obstructing is a gross misdemeanor, 364 days and or 1,000. Disorderly conduct is a simple misdemeanor. The max is 90 or 1,000. The weapons charge is a likewise 90 days and or 1,000. Mr. Johnson, I'll appoint Mr. Haverco to enter a plea in your behalf, and he'll represent you throughout the course of the matter, should you be indigent and request his services.
Stipulate probable cause, ask the court to enter not guilty, please.
Usual stipulations. Mr. Haverco, usual stipulations as to.
Oh yes, stipulate the probable cause, ask the court to enter not guilty, please.
Thanks. You say that all a PC means, probable cause, is that the very low threshold that the officer had some reasonable basis upon which he could issue the citation. Doesn't mean you did anything that's of a criminal nature.
Here you go, Your Honor.
That concludes the hearing. Take it easy. We'll see you back here on the 19th. Any questions? Have a good day.
9 a.m.
I think it was 11 o'clock. I already closed my copy of the order, but I believe it was 11. 10 a.m. And that'll be in the order. That'll be in there, as well as the court's phone number and Mr. Haverco's contact information, his phone number as well.
Thanks.
Okay. Thank you, sir. Take care. Kevin Kiesler. Good afternoon, sir. First name, full name Kevin Christopher Kiesler. Citation alleges that on or about November 9th, 2024, you committed the offense of driving a license suspended or revoked third degree. You've heard what usually happens. The city is nodded in my general direction, which means they're amending the charge from the criminal offense to a civil infraction. And if you were listening earlier, that means no jail time is possible. If you admit the infraction, it's a $150 fine. If you deny the infraction, you have a right to a contested hearing, which is set for a later date. Any questions? Then do you admit or deny? 150. Now, do you know what you need to do to get your license back? That's what I really, good. It's money. It's so easy to lose and it's so hard to get it back, and it's generally a question of money. But I'm going to wish you the best of luck. But unfortunately, we live in a world where you pretty much have to be able to drive to function at all. With that being said, and here we are. It's expensive, but we're adding to the misery today. But good luck getting reinstated. Don't forget to get a copy of the order before you leave.
Yep.
Mr. Keesler, good luck.
Thank you.
Excuse me a minute. I got a little ahead of myself. Christopher Kenny in the courtroom. Christopher Kenny. Good afternoon, sir. Is it Christopher Freedom Kenny?
Yes.
Mr. Kenny, the citation I have alleges that on or about November 16th, 2024, you committed the offense of DWLS 3rd degree. Again, that's a misdemeanor, maximum penalty of 90 days in jail and or a $1,000 fine. This is Mr. Kenny. City have a motion in this case. That's docket number 13, page 14. Number 13, page 14. Mr. Kenny, this citation has likewise been amended to the civil infraction. It's if you admit the infraction, it's another 150. If you deny it, it's we're gonna have a contested hearing. What do you want to do? Pardon? You're admitting it? Mr. Kenny, it's if you keep getting these, eventually some judge is gonna do what you can do to get your license reinstated. Money. It's all money. It's 150. Sign the order to that effect. Go ahead and get a copy of the order at the window, and good luck to you getting reinstated. Take care of yourself. Maribel Lopez Pastrana. Good afternoon, ma'am. You were cited for the same thing, driving a license suspended, revoked, 3rd degree. The city's nodded in my direction, which means the city is amending the charge to the civil infraction of no valid operator's license on your person. By now, you know what that means, I assume. If you admit the infraction, it's a $150 fine. If you deny it, you're entitled to a contested hearing. Any question about what I just said? What would you like to do? Admit or deny? 150 is the fine. And that's, yeah, do you know what you need to do to reinstate your license? I would make that a priority in life. We live in a world where you kind of hard to get along without a license. I'm signing the order, setting the fine at 150. I want you to get a copy of the order at the window outside. You can make payments on that, $25 a month. But yeah, please, I want to reinstate your license. Good luck to you. Take care of yourself. Tanner Lunsford.
That's the fellow, Your Honor, where I had received a phone call message
Oh.
from his mother indicating he is purportedly in some kind of inpatient treatment facility in Vancouver, so,
remember
yeah.
from this morning's calendar. We'll come back to that.
Okay.
Shane Maloney? Shane Maloney in the courtroom. Good afternoon, sir. Is your full name Shane Ryan Maloney? Maloney, the citation I have alleges that on or about November 5th, 2024, you committed the offense of DWS third. That's the simple misdemeanor with a maximum of 90 days and or 1,000. You were also cited for driving under the influence of intoxicants. That charge is a gross misdemeanor. The maximum penalty and conviction for that would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter, Mr. Maloney, and he'll enter a plea on your behalf at this time.
Thank you, Your Honor. Stipulated probable cause, ask the court to enter not guilty, please.
Pleas of not guilty have been entered, preserving your rights. Mr. Maloney, conditions of release are law-abiding behavior. Don't drive unless licensed and insured. Any officer asks you to take a breathalyzer, you're to do so, and absolutely no drinking and driving at the same time.
Good phone number. One second.
Maloney, any questions at all? Unless you have any questions of Mr. Haverco, that concludes the matter. Get a copy of today's order at the window outside and to your left, and we'll see you back here in December. Good luck to you. Ashley McCarty. Good afternoon, ma'am. Full name Ashley Michelle McCarty. Ms. McCarty, the citation alleges that on or about November 12th, 2024, you were in possession of a dangerous dog. That charge is a misdemeanor. The maximum penalty on conviction would be 90 days and or a $1,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf, and he'll represent you in this matter.
Stipulate probable cause, Your Honor, ask the court to enter not guilty, please.
McCarty, the plea of not guilty does preserve your rights. Conditions of release are law-abiding behavior. The dog that's alleged to be dangerous, and where is that dog now? Please get a copy of today's order at the window outside the courtroom to your left, and we'll see you back here next month. Any questions at all? Good luck. Mr. McNinch, that's dealt with. How about Samuel Newman? Mr. Newman, come on up here finally and have a seat. Full name, Samuel Newman. Mr. Newman, the citation alleges that on or about November 8th, 2024, you violated the terms and conditions of a protection order. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days jail and or a $5,000 fine. I'm going to assign Mr. Haverco to represent you in this case. He'll enter a plea on your behalf at this time.
Stipulate probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Newman, a plea of not guilty preserves your rights.
Yes.
Conditions are. Any questions? Conditions, law-abiding behavior, and that would include don't violate any existing no contact rules. Okay, good. Mr. Newman, go ahead and get a copy of today's order at the window.
I gotta hit sign first. Yeah. I have to wait till she. Yeah. It'll be in your paper. Yeah, free to go. Just go see the clerk before you go and get a copy of your paperwork. That'll have a copy of your court date.
And that's it. You're done. And again, as Mr. Haverco said, get a copy of the order. Brittany Perkins. Good afternoon, ma'am. Full name, Brittany Danielle Perkins. Ms. Perkins, the citation I have alleges that on or about November 10th, 2024, you committed the offense of driving while under the influence of intoxicants. The charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and represent you in this matter.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights, Ms. Perkins. We'll set it for a pretrial. That will be on December 19th of 2024. Conditions of release in the meantime are law-abiding behavior. Don't drive unless you're licensed and insured. Any officer asks you to take a breathalyzer, you're to do so. And absolutely no drinking and driving at the same time.
Sign it. Pick up your paper before you go to every court date. No, fine.
Seth Rome in the courtroom. Seth Rome. How about Aaron Schroeder? Does not appear. Charles Smith. Come on up, sir, and have a seat. Afternoon, sir. Is your full name Charles Henry Smith?
Sir.
Citation I have alleges that on or about November 19th, 2024, you committed the offense of driving while under the influence of intoxicants. That is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to represent you in this matter and enter a plea on your behalf.
Stipulate the probable cause, Your Honor, ask the court to enter a not guilty plea.
Plea of not guilty preserves your rights pending the pretrial, which we will set. Conditions of release, law-abiding behavior, don't drive unless licensed and insured. Any officer asks you to take a breathalyzer, you're to do so, and absolutely no drinking and driving. Any questions? There is a speeding ticket issued along that. We'll calendar that along with the criminal offense, so we don't have to do anything about that at this time.
Yep. Yeah, so before you go, just look for the clerk's window. They'll give you a little printout of paperwork from today. And we'll have your next work. Yeah. Take care.
Any question at all, Mr. Smith? Good luck to you. Take care. Tennille Squally. Good afternoon, Ms. Squally. How are you? So far, so good. It's a little difficult with the weather out there, but that's all right. You were cited for DWLS third degree, which is the criminal offense. City may have a motion in that. The city has moved to amend the charge to the civil infraction. And by now, you probably know what that means. If you admit it, that's a $150 fine. If you deny it, we can set it for a contested hearing. What do you wish to do? And we'll set your payments at $25 a month. Now, do you know what you need to do to reinstate your license? Usually money. Oh. Reinstatement. Good. I'd make that a project in life, the number one project, and get your license reinstated so you don't have to talk to people like me on a basis. I'm going to wish you the best of luck. I'm signing a order resetting that to a $150 fine. You take care of yourself. Enjoy the rest of the day, and don't forget to get a copy of the order on the way out of the courtroom. Ms. Qualley, thank you. You take care of yourself, and you as well. Darren Toms. Good afternoon, sir. Is it Darren Eugene Toms? Mr. Toms, the citation alleges that on or about November 9th, 2024, you committed the offense of reckless driving. A gross misdemeanor. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time. Mr. Haverco.
Thank you, Your Honor. Stipulate the probable cause, ask the court to enter not guilty plea.
Mr. Toms, a plea of not guilty entered on your behalf. You were also cited for no insurance. We'll just calendar that along with the criminal offense, setting both for a pretrial on December 19th at 11 o'clock.
I need your signature on this.
Toms, I've signed the order at this point.
I also need a phone number for you. Do you have them? So what I would ask that you do is, when you get your paperwork, it'll have your court date, it'll also have some information.
Sounds good luck. Take care.
Oh, this is Mr. Ehrlich from the 11 o'clock?
11 o'clock and 1 o'clock. Them?
No. 01. Was it actually
I guess
noticed
just,
for 1 o'clock or was it?
I'm,
Okay. So maybe we could take Mr. Ehrlich's matters and.
sure.
Ehrlich,
Mr. Ehrlich, come on up and have a seat.
I think you'd wanted a continuance anyway. How far are you trying to continue? You know, we had a motion for continuance in Oak Courts. I don't know.
Yes,
if
it's
we-
right here. It's
Oh,
here.
so, yeah,
If that's your motion,
yeah. Yeah, I think we should. Yeah, let's go ahead and do.
that's why I said 1 o'clock. I
Right, I
forgot
know,
which
yeah.
document it's on.
Yeah, so let's do the arraignment on the arraignment matter and the motion that continues on the other pretrial matter.
And that's, it might indicate I'll take the plea and I will hear the matter if there's full agreement on everything. But I know Mr. Ehrlich from tribal court, if either side objects for me being here, or Mr. Ehrlich doesn't want me to sit as the judge in this matter, I'll gladly step down.
He has no objection, Your Honor, to you being
the-
assigned to this case.
The new charge is obstructing a law enforcement officer on November 13th. That's a misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Have Mr. Haverco enter a plea on your behalf with regard to that
Yep.
charge, and he'll represent you on that one as
Okay.
well.
Okay, so stipulate the probable cause, Your Honor, and ask the court to enter not guilty plea.
In order, set the matter, well, we're resetting the matter for a pretrial on, how far did you want to go?
We wanted to set it into January. Set it into January. Motion to continue.
So mine
Sign.
doesn't show the date and time. Oh, okay.
No. He has just signed the motion to continue. Oh. Oh, okay, all right. Oh. Oh, okay. You have court, sir? You have court? You have court here? Oh.
Oh.
Well, you were saying here. You have court. Mr. Schroeder?
That's Aaron Schroeder. Like that.
Oh, so you're free to go. Just pick up your paperwork at the clerk's window before you go. What calendar is Mr. Schroeder on?
He's on the arraignment calendar.
Oh.
Schroeder, you might talk to him a little bit. He's almost impossible to communicate with. He extremely
Oh. Okay.
hard of hearing. You're gonna have to really speak up. You might even have to write. That's
Number. So, yes, we see.
Good afternoon, sir. Is your name Aaron Troy Schroeder? Are you Mr. Schroeder? I don't know how we're gonna deal with this. Apparently, he's almost, I'm gonna say about 100% deaf. It's
Wow.
and I did release him for court, but impossible to communicate with them. Mr. Schroeder, have you seen a doctor about your hearing? Have you seen a doctor about your hearing? Do you know how to sign at all? ALS? You know sign language? I don't know enough of that to. Perfect.
Oh.
Do we?
Oh, you know.
Let's reset the arraignment, Mr. Haverco. We're going to reset the arraignment to a later date.
Oh, okay.
And what do I used to know? Officer Runkles, I believe there's an app to I was driving on the freeway. My ex-wife was with me. There was a motorcycle in the fast lane. It was obviously on his motorcycle, and on his, and he was signing to whoever was, that he was communicating with at 70 miles an hour going down the freeway. Good afternoon. We apparently have one person who's appeared for the 2:30 contested calendar. I should say, these are both contested hearings. Have one person here on behalf. I'll introduce yourself for the record and
Absolutely. This is Attorney Robin Tu. I work for Roberto Irinella. I'm here on behalf of Jonathan Lopez, 480688415.
set for a contested hearing at this time. I assume there's some preliminary motions. I'll hear them now.
Thank you, Your Honor. One preliminary motion is that there's no agency mentioned anywhere in the entire narrative, nor logically associated with the signature, nor in the signature. So our motion is under RCW 550-0103E to suppress and dismiss.
Yep, that, I don't think you need to go any further than that. The motion is granted. That'll be followed by a motion to dismiss. Dismiss granted. We do have an infraction form. I will sign the order of dismissal. And a copy of that can be gotten at the window outside the courtroom to the left. Clients always like to see an order that says dismissal on it.
Right. Is it in O courts as well, Your Honor? Is it in O court as well?
Yes, oh yeah, it's in Oak Court.
Okay, then I can just pull it from there. as
You
well.
got it, okay, good,
Yes.
good. I'm a bit of a cyber dinosaur. I'm still catching up to the electronic age.
Right.
But yes, I signed the order of dismissal and that's in Oak Courts.
Okay. Does Mr. Motto have a case here by chance today? He just sent me a text and asked.
Yes, he
me if I
does.
was-
Yes, he does.
Oh, he's on.
Writer Will, what now? Oh, he is on Zoom, okay.
Since when was there a Zoom option? I had no idea.
I remember that for the future. I want clients here, if it's a criminal matter, of course, you can waive presence for an infraction.
Right.
But yeah, attorneys can always appear by Zoom if they have that option. Now you know.
Now I know. I just drove.
Why didn't somebody tell you that?
They told me in person only. I drove an hour and a half for one case. That's what they told me. Maybe it was a prank.
I would certainly hope not.
I'll give him the update. Thank you, Your Honor.
Okay, hey, thank you, sir. You take care. Good luck. I hope it isn't an hour and a half back.
Okay, nothing else.
Oh, well, there are probably better things to do than sit on the freeway.
Talk to you later. Thank you.
Take care. Thank you. Go ahead and bring. Good afternoon, Mr. Matto. I see you're here representing Writer Wells, contested hearing for a speeding ticket. I have that matter in front of me. I presume, do you have something by way of preliminary motions? I'll take them now.
Thank you, Your Honor, and good afternoon to the court. First time seeing you, Your Honor. Nice to meet you. I'm here for Mr. Wells. So, Your Honor, my first argument on this case is to suppress the narrative report pursuant to RCW 5.50010 subsection E. There's no agency noted in the signature block of this infraction. Therefore, we believe there's a faulty declaration.
I agree with you. That's the motion I've heard more than once. Motion granted. Take it followed by a motion to dismiss.
Yes, Your Honor. Motion dismissed for lack of evidence.
So ordered. It's in O courts. I am signing an order dismissing the citation at this time. If you have O courts, you can pull that up. I take it in that. I didn't realize that, but if not, we can send you a copy.
Yeah, I have access to O court. I'll get a copy loaded down for my client. Thank you very much for the correspondence.
Okay, concludes the hearing. Ticket
It
dismissed.
does, Your Honor.
Take care. Have a good day.
You too, Your Honor. Thank you.
Back on record for the no-shows. The first one I have is docket number 4, page 12. Christopher Wayne Benishek, I find probable cause for the issuance to him of theft third citation. The next one, Kevin Bingaman, we were gonna do something with him. He was field booked. And he did not reappear, so warrant will reissue probable cause having previously been found 1,000 cash or bond. Next would be Jacqueline Channon, number 6. DWS, there's a reset request in the file. Go ahead and reset that one. That's a daughter having surgery, Auburn Medical Center that day. That's a good enough reason. Let's reset that one. Next is James Haas. Probable cause was previously found. He's been released from on a couple of times. 1,000 cash or bond. Same way with Seth Rome, the last one I have. Probable cause previously found when he was released from custody. 1,000 cash or bond on each. We have a couple of other DDoS thirds on, let's go to page 14. Kevin Kiesler, wait a minute, I think we did him. I didn't make a, that would, Tanner Lunsford, he was the one that we were expecting this morning. On this one, amend to Noval 2 and FDA. On this morning one, what did we do with him this morning? Reset that. And I think, is that it? I believe so. Yeah, Mr. Roman, Miss Hot.